Hello again, my name's Gabe Zolna. Well, I found this to be rather fascinating. You might feel much the same way. I posted MVI 8313, Serena Williams and Venus Williams, male or female. It's received some interesting comments, and one in particular. The viewer wrote, "They're not tested because testing is not required since 1978. The Supreme Court ruled that transsexuals can legally play women's tennis, a result of sex rights lobbying." I went ahead and I did some Googling, and I'm going to read you what part of this article that I found reads, and I'll attach it because there's an awful lot of additional information that you might find to be interesting. What this really tells me is that anyone that wagers on the tennis game when either Venus or Serena are playing is going to make money. It starts off under Article 6 or Item 6 because there's 6 different series of pieces of information in this article. Number 6 is sports. The potential for fraud in women's sporting events has been a concern of Olympic committees for years. As early as the 1960s, the Olympics became concerned with the issue of men competing as women. At first, the committee's plan to detect gender fraud was to conduct nude lineups of the athletes prior to competition. The committee stopped this method of fraud detection and began conducting chromosome tests. What is interesting is that they did not stop because they felt the lineup was inaccurate. They thought that they were too intrusive and embarrassing. Their new approach unveiled a new issue. Some Olympic athletes intersexed. The committee encountered athletes with female genitalia and either a chromosomal combination other than XX or those that had androgen insensitivity syndrome and AY chromosomes. Both were disqualified. Years after disqualification, some of these women had babies, and the Olympics, realizing that they had wrongfully accused these athletes of fraud, rethought their need for gender verification. At first, they took a step back and conducted a spandex test. The theory was that a man could not hide his penis in spandex, and the test was less embarrassing than a lineup. However, the test was short-lived, and in 1992, the committee eventually did away with testing altogether. How will sports deal with transsexuals that have SRS? If a post-op male to female transsexual made it into the United States track team, could she compete? She would pass the Olympic nude lineup test and the spandex test. According to the chromosomal standards from Lytton, she is legally a male. However, under the genitalia standard used in prison assignments, she is a female. This still doesn't answer the question as to whether she is a fraud. She would medically and psychologically be a female, and the female hormones would have replaced the testosterone that may have given her a competitive edge. In Richards versus the United States Tennis Association, a post-op male to female transsexual was allowed to compete as a female tennis player. Richards, a 41-year-old physician, was nationally ranked as a male tennis player. After living as a transsexual for years, Richard underwent SRS. After completing SRS, Richards competed successfully as a woman in 9 tennis tournaments. In 1976, Richards applied to qualify and play in the U.S. Open, completely disclosing her medical history. In order to play as a woman, the United States Tennis Association required Richards to submit to sex chromosome test. The USTA felt that the test was a reasonable way to ensure fairness and equality of competition when dealing with numerous competitors from around the world. The bar body test takes a cell sample from the athlete's cheek and searches it to ensure that the athlete wanting to compete as a female has XX chromosomes and not XY. The Y chromosomes gives males the average greater height, different body proportions, and higher muscle mass than females. The existence of a Y chromosome would presumably give an athlete an advantage if playing against athletes that did not have Y chromosomes. Under the bar body test, Richards would be a male. Richards, experts pointed out that the court agreed that while the bar body test would classify Richards as a male due to extensive hormonal treatments and surgical procedures, Richards' body no longer responded to Y chromosomes in a way that would give her a competitive edge. At the time of application, Richards had the height, muscle mass, and hormonal makeup of the average woman. Therefore, the court held that requiring Richards to submit to the bar body test and holding the results as determinative of her status as a competitor was grossly unfair, discriminatory, and inequitable, and violates of her human rights. Under Litton, Richards seems to suggest that the confining a post-op transsexual to chromosomal-based sex classification is grossly unfair. I find it interesting that the content of marriage, the only criteria relevant to determining a person's sex, is what God gave them at birth. In the content of prison assignment, the relevant criteria is the presence of genitalia. And in the content of sports, sex is determined by the actual functioning of the body. In none of these contents has the criteria been set at gender identity alone. Should it be? I doubt that the court would have found it grossly unfair if Richards should be denied the right to play in U.S. Open if she had not undergone SRS to hormone treatments. Without such treatments, her X chromosomes would give her a competitive advantage. In the absence of SRS, a chromosome test seems justifiable in the contents of sports. Litton suggests that the same test should be determined in a sex classification for the purpose of marriage. It is chromosomal test justifiable or unjustifiable in the content of marriage. The same reason that it is in the content of sports. The conclusion, as this paper has shown, determining a person's sex can be a difficult task. Science attributes this difficulty to the fact that there is a gender spectrum varying between the two extremes of XY male and XX female. To complicate matters further, the legal system was created on the assumption that there were only two sexes. The system does not acknowledge the portion of people that fall in between as having a gender other than male or female. Rather, it looks primarily to the person's physical characteristics at birth and assigns the person a sex on that basis. Now that times have changed and many transsexuals are openly living as the sex that they identify with, the issue of defining what is a man and a woman has become more complicated. Transsexuals are challenging the rigidity of the system and are pushing for a definition of sex that looks beyond historically accepted criteria. While the courts have set precedents for defining sex in the 21st century, they have created different rules for defining sex that vary with the legal content. The result is that people with ambiguous gender have ambiguous legal rights. For example, a post-op male to female transsexual may be assigned to a female prison. She would not be a female in the contents of marriage. In the contents of marriage, sex is defined primarily by looking at chromosome factors. This standard assumes that regardless of gender identity, hormonal characteristics, and changes made to hypotypical sex characteristics, a person is stuck with the sex corresponding to their immutable chromosomal makeup, presumably either XX or XY. On the other hand, in the content of prison assignment, sex determined the existence or the non-existence of a penis. Therefore, a male to female transsexual may be assigned to a female prison provided the penis she was born with has been surgically removed. Similarly, a pre-op male to female transsexual will not be allowed to change her name from Mike to Michelle until she has undergone complete SRS. In the contents of sports, It's determined by the actual functioning of the body. You know what's interesting is this does actually say Mike to Michelle. These inconsistent standards are unfair to transsexuals because they are left unsure as to when they are male and when they are female. I think the legal system should acknowledge the gender spectrum. In doing so, the system should give transsexuals the opportunity to legally identify with the gender of their choice, provided that the transsexual can show a history of identifying with the gender that they've chosen. Under this method, chromosomal makeup, hormones, phenotypical characteristics, and gender identity will be considered. However, the existence or non-existence of one or more factors would not be determined. I also recommend that once a transsexual is legally assigned to a particular sex, he or she would be recognized as the sex in all contents. This would leave the transsexual on equal standing with the majority of society, in that he/she would be confident of his/her sex in the eyes of the law in general. Is that sort of clear? What this really means is that Vanessa, or Serena, I apologize, Serena and Venus are, in fact, according to the Supreme Court, women. I don't know, folks. I'm going to attach the link again, and there's a great deal of additional information that doesn't just deal with the sports. It deals with same-sex marriage, deals with mandatory chromosome testing. There's an awful lot of information here. Transsexual marriages, hermaphrodite marriages. You know what's amazing is the impact that the Supreme Court has on pretty much everything. This is an example, as is Obamacare, thanks to Justice Roberts.